The framers of the Constitution wanted to protect states' rights and ensure that states were a good defense against tyranny. However, they were creating this whole new federal government, this national government, and they wanted to give that government power. So the Constitution, even though it outlines a lot of provisions whereby states have some power, it does give that federal government quite a bit of power too. Specifically, it gives Congress power to intervene in national emergencies. This is part of the necessary and proper clause. Sometimes we call it the elastic clause. This is because the words of the Constitution say that Congress shall be able to do what is necessary and proper to carry out their enumerated powers. And that has been stretched to cover a lot more than intervening in national emergencies. So as it stretches, it's elastic. So we can call it either. I tend to call it the necessary and proper clause because that's what it was in the textbook I learned this from, but your textbook says the elastic clause. So either is completely fine. Now, again, this was meant to just allow Congress to intervene in emergencies, but it has been stretched to allow them to do an awful lot. The Commerce Clause was really just there to avoid the problems under the Articles of Confederation, right? All these state-to-state conflicts because interstate commerce wasn't regulated by national power. So this gave the federal government power to regulate interstate and international commerce. But this has been interpreted pretty broadly too. So for example, the Commerce Clause has given the federal government a lot of power over drug laws, because if you buy drugs in one state, it would be pretty easy to just transport them to another state, right? So that is interstate commerce. You are buying and moving things across state lines. So that would allow the federal government to intervene. And even though you don't have to bring something across state lines, there is an assumption that you could, and therefore that the federal government can intervene in these situations. Now that has led to this really weird patchwork, right? Where individual states may actually have laws that don't align with federal drug laws. For example, New York State allows for now licensed dispensaries, but that does seem to conflict with federal law. So New York is very careful to say that these dispensaries must only use product from New York State, must only sell this product within New York State. That is intrastate commerce, which the state has power over. But the federal government may say, but wait, what if someone from New Jersey goes into New York and buys this? How can you say this doesn't have interstate implications? For the most part, the federal government has stayed out of these types of things, but in theory, the Commerce Clause may allow them to intervene. And in practice, these powers have been broadly interpreted by the Supreme Court when cases have come to them about these kind of issues.